Good afternoon, everyone. My name is Christina Thill, and I'm the State Tobacco Policy Planner for the Minnesota Department of Health, and I am also the Policy Chair for the Tobacco Control Network. On behalf of TCN, I am so happy to be joined by our co-organizers at the Public Health Law Center for this second virtual session in a collaborative three-part series on tobacco policy preemption and its impacts at the state and local levels. Today, we will explore the tobacco industry tactics for passing preemption legislation at the state level. Next slide. As you can see, we have a full agenda to cover, which will allow us to get a full background on tobacco preemption from subject matter experts at the Public Health Law Center and the American Cancer Society Cancer Action Network before diving into two state-level case studies on the tobacco industry's political influence at the state level. We'll start with a brief overview of the Tobacco Control Network before I turn the floor over to the Public Health Law Center co-hosts. Next slide. The mission of the Tobacco Control Network, a peer network of the Association of State and Territorial Health Officials, or ASTHO, is to improve the public's health by providing education and state-based expertise for tobacco prevention and control at the state, territory, and national levels. We are excited to recognize 2019 as the 25th anniversary of TCN and celebrate all the successes our state and territorial tobacco control members have had in achieving tobacco control best practices. Next slide. TCN established this 2016-2019 strategic map to help achieve its mission of improving the public's health by advancing state and territorial tobacco prevention and control. As you can see, the TCN Executive Committee prioritizes specific objectives in our support of state and territorial tobacco control and acknowledges health equity as an overarching principle. A new strategic map will go into effect this fall with the opportunity for the TCN membership to provide insights as it gets finalized. Next slide. It's now time to hear from the speakers joining me today. First, I am happy to introduce Mark Meany. Mark is the lead senior staff attorney for the Tobacco Control Technical Assistance with the Public Health Law Center. Mark provides legal technical assistance on tobacco control issues and other public health law issues to public health professionals and organizations, attorneys, and advocates throughout the United States. Mark also provides training on the development and the implementation of tobacco control policies in state and local communities. Mark, the floor is yours.
Great, thanks, Christina. And thanks to everyone for joining us today for what we think is a really important topic. I just want to talk a little bit about a couple of things before we hear from some of the experts on the ground. And my simple takeaway is that I can't overemphasize how important of a policy issue preemption is. I think that we've all learned that there is no acceptable level of preemption, and that as much as we think it's in some cases an okay trade-off for policies that we want to see move forward, we have learned over time that that preemption is a really nefarious policy, and it ends up harming us in the end, harming public health in the end. We can go to the next slide, please. So I think most of you know our organization. As Christina said, I work at the Public Health Law Center. We are a nonprofit 501c3 located in St. Paul, Minnesota at the Mitchell-Hamlin School of Law. And in the interest of time, I won't talk too much about our organization except to say that if you have any questions about tobacco control issues, we provide free legal technical assistance, and so we would be happy to talk to you about any issues that you may encounter. Next slide, please. So in our last webinar, if you had a chance to listen, or if you haven't yet, I encourage you to listen in. It's still archived. We talked more about what preemption is and explained a little bit more what the concept is. And so I don't want to go too far down that road today, but I do think it's important to have at least a little historical and legal context about preemption. The concept of preemption itself is an essential part of our legal system and has been since its inception. If there are conflicts between laws that are established at different levels of government, there has to be a way to determine which law to follow. That all makes sense, and it's an essential component of our federal system of government. But it was the tobacco industry, and I know Ron's going to talk more specifically about this directly, that developed the strategy of weaponizing preemption simply as an attempt to impede local authority. And we know good policies and good model public health policies are developed and refined at the local level before they become adopted at the state and the federal levels. So local control is essentially is extremely important for all the work that we do. Next slide, please. At the Public Health Law Center, we approach all of our work through a health equity lens. Unfortunately, the successful targeted marketing of tobacco products by the industry has resulted in tremendous health disparities. While it doesn't always seem evident, preemption is a fundamental health equity issue because it helps to perpetuate and exacerbate those health disparities. This is true in a lot of areas, but it's especially true in tobacco control. We know that we've achieved a lot of success in lowering tobacco use among most populations. Unfortunately, what we often miss when we look at macro numbers is that the gains that we have felt that we have made are not always felt by all communities in the same ways. And so sometimes with our gains, we end up glossing over or missing some of the areas that have the greatest needs. So communities of color, lower income communities, and the LGBT population, all these communities that have been directly targeted by the tobacco industry haven't seen those same successes. And so preemption is one area that we want that helps to maintain those health disparities, unfortunately. So we know that when we develop policies to address public health concerns, those who are closest to the community, those who know the unique issues that a community faces, are those who are most able to develop policies to address those. And so tailored policies are the best policies. Next slide, please. One key but it's often an overlooked problem with preemption is that its scope isn't always clear from the plain language of a statute. And so when we see it as often we see it as a trade-off for another policy, we don't know what the extent of it is going to be until a court decides that. So as a result, we have preemptive laws on the books and end up having a really significant chilling effect on all kinds of local activity. Understandably, and it makes a lot of sense, local governments don't want to be sued, and so they're going to actually make the preemptive law broader in many cases to avoid the potential litigation, because we know that we're working with an industry that has no qualms with bringing lawsuits. And also, preemption has changed a lot over the last 30 years. As when we first saw the initial preemption in Florida, we're seeing a lot more diversity in the types of preemptive laws. They're being tied to popular policies, as Lila will talk about. We're also seeing the influence of groups like ALEC, which develops these model preemptive policies. I know Kathy's going to talk more about this, and they train legislators on how to implement these policies. And we're also seeing preemption in areas that outside of tobacco control that also influence tobacco control. So the preemptive laws have gotten more sophisticated. Next slide, please. And historically, courts have been reticent to find preemption when there were challenges. When there was a question of preemption, courts would typically look at the plain language of the law and try to figure out whether it was clear, whether there was any express preemptive intent. They would look to see if the law, if there wasn't express preemptive intent, they would look to see if the laws were in conflict and whether it would be possible to comply with both of those laws. And if so, if it was possible to comply with both laws and there wasn't any clear evidence from the legislature that they intended preemption, the courts would generally find a way for the laws to coexist. Unfortunately, recently we are seeing some state courts moving in the opposite direction. This occurred to some extent in Florida, again, and Ron will talk more about this. We saw this in Wisconsin with a surprisingly broad court decision. And then most recently, and I'd say definitely the most surprising decision so far, is in a Tobacco 21 litigation in Kansas, where the city of Topeka passed the Tobacco 21 law, where there was no express preemptive language. In fact, there was an AG's opinion from the state saying that in this case, Topeka had adequate authority. In addition to that, there were almost 20 other jurisdictions that had a Tobacco 21 law in place in Kansas. And the district court in the case state still found that there was a field preemption and the city didn't have adequate authority to pass this law, which runs counter to the many years of jurisprudence that we have seen. And and it was, you know, it was a surprising and disappointing decision. It's now being appealed to the state Supreme Court, and we are hoping to hear a decision very soon that will overturn that. But again, we just don't know what the extent of it's going to be. Next slide, please. That leaves us with the importance of diligence and good drafting. And I know Kathy is going to talk a little bit more specifically about this, so I won't go too far into this. But looking for, just generally want to say, looking for certain types of words. Often the word preemption isn't what the statute's going to say. It's going to use other words, uniform, exclusive, occupy the field, things like that, to try to be a little bit less direct, I suppose. And then looking everywhere, as I said before, we're seeing more laws that are not just directly in the tobacco control section of the state statute, but are more related to consumer goods or something broader that will implicate and preempt local activity in the tobacco field as well. Next slide, please. And then finally, when there's new legislation, not leaving anything to chance, making sure that there is very clear and direct anti-preemption language is very, very important. And next slide, please. And then finally, there are a lot of resources out there. The folks on the phone here, among many others, can help out when there are questions about preemption. And next slide, please. And I encourage you to contact us or contact other organizations, as we mentioned here, and we can help talk to you about particular language to see what we think. We'd be happy to provide that help to you. And I'm gonna, with that, I'm pleased to turn things over to Kathy Calloway. Kathy is an expert and has an incredible amount of on-the-ground perspective on this topic. She is the Director for State and Local Campaigns for the American Cancer Society Cancer Action Network, and she has an incredible wealth of expertise on how the tobacco industry influences state tobacco policy in ways that are unfavorable to public health. I just want to thank Kathy so much for joining us this afternoon and turn it over to her.
Thanks so much, Mark. Hi, everyone. Hope you're doing well today. I firmly believe that by monitoring what the tobacco companies say and do, we can better anticipate their next move. They have made it very clear that preemption is their top priority. Next slide, please. As you can tell from this quote from Victor Crawford, a former Tobacco Institute lobbyist, and this quote is from 1995, the Tobacco Institute and tobacco companies' first priority has always been to preempt the field, preferably to put it all on the federal level, but if they can't do that, at least on the state level. Next slide, please. And then here's another quote from R.J. Reynolds. Industry leaders have recognized that state laws that preempt local anti-tobacco ordinances are the most effective means to counter local challenges. Next slide, please. And as there is a lot of activity around raising the minimum age of sale for tobacco products at all levels of government, I thought this memo from R.J. Reynolds from 1989 was especially timely and listed under, quote unquote, the fallback position regarding bills to establish 18 years of age as the national standard. Now remember, this is from 1989. Accept minimum federal standard of age of 18 years of age in return for maintaining federal preemption of health warnings or avoiding other onerous proposals. I'm thinking we're going to need to keep our eyes on those closely on those federal bills that are currently in play. And isn't it fascinating to think that they were willing to accept a fallback position of 18 years of age, and here we are 30 years later, and we're just now considering 21. Anyway, next slide, please. Again, in their own words, with or without federal preemption, it seems the tobacco companies are serious, dead serious, to quote them, about achieving preemption in all 50 states. And this is a quote from Tina Walls with Philip Morris in 1984. And I'll point out here, just a reminder that Altria, the parent company of Philip Morris, is also owns 35% of the new Juul e-cigarette company. So my guess is they're learning from the playbook from Philip Morris and R.J. Reynolds as well. So next slide, please. As Mark mentioned, there are different types of preemption and words to be on the lookout for. Sometimes the preemption is very clear. Other times it's more confusing or even conflicting. Sometimes the language allows local laws, but doesn't allow enforcement of those local laws, which obviously creates a problem. While the industry strategy and language might change, their ultimate goal remains the same. The next few slides here are some examples of language that we saw or dealt with this year. So this first bill is language we saw in South Carolina. And you'll note it's pretty straightforward as to the intent. It clearly states that political subdivisions of the state may not enact any laws, ordinances, or rules. The language also provides a clear map of what the industry's concerns are: the regulation of ingredients, flavors, and licensing. Next slide, please. This is language that we saw in Florida. Again, very direct, that the sale and delivery of tobacco products and regulation of marketing is preempted to the state. Fortunately, this bill did not pass. Neither did the one previously in South Carolina. Then this next slide here, this one is from Arkansas, and you'll see this is an example of more restrictive or stringent than language. And this bill, unfortunately, did pass, and it makes it clear that more restrictive local regulation of the manufacturer, sale, storage, or distribution of tobacco products is preempted. So very broad language in Arkansas now. Next slide, please. Now this is language, an example of uniform application. This language is already on the books in Iowa, establishing uniform application, and this is specific to the enforcement. And it goes on to say that it'll be implemented in an equitable manner throughout the state. Now, a bill was filed this legislative session in Iowa to raise the age of sale for tobacco products to 21. And when we asked the bill sponsor, who had introduced the bill on behalf of Jewel, to remove this language that was already in the code, he not surprisingly refused to do so. So that language is still on the books, and the Tobacco 21 bill did not pass. Next slide, please. And here's an example of superseding language. This is also already on the books in South Carolina, and as an example of how the term supersede is used to convey preemption. Next slide, please. And here is language from a bill in Arizona as an example of matter of statewide concern language. Again, the tobacco industry is concerned with local laws over the sale and marketing of tobacco products. I don't know about you, but I think when we're looking at those federal Tobacco 21 bills, I could see the industry being very willing to accept a federal age of 21 in return for some preemption over some of these sales, marketing, flavored ingredients restrictions that they seem very concerned about preempting in states. So fortunately, the Arizona preemption language did not pass. So good news there. Next slide, please. So as Mark said, it's very important to look everywhere. Look at bills that public health interests are introducing, look at bills that the tobacco industry is introducing, and monitor them all. We've seen preemption language added to seemingly well-intentioned bills to raise the age of sale to 21. But again, that preemption is put in there as what's in it for me, for the tobacco companies. E-cigarettes have also spawned a lot of legislation in states that have become a convenient vehicle for the tobacco industry to insert preemption language into. Certainly with the wide proliferation of marijuana laws being introduced in states, both medical and recreational, we're seeing some extra hoops being added to limit what local governments can do. For example, taking things to the ballot to get it approved by the voters before it can be put into law at the local level. Further restrictions on marijuana use or sales there. Fracking, minimum wage, paid sick days, discrimination laws, anything dealing with agriculture. We saw a bill in Georgia 2 sessions ago that would preempt anything dealing with a product that is regulated by the State Department of Agriculture, the Federal Department, the U.S. Department of Agriculture, the Federal Food and Drug Administration. It was very sweeping. So obviously that would capture anything tobacco related, but also a lot of the nutrition policies that we're seeking at the local level too. Fortunately, that bill in Georgia did not pass. So, and one other thing I would just point out, just because you have preemption on the books somewhere already, that doesn't mean you're free and clear. Unfortunately, we're seeing a trend of the tobacco companies adding preemption anywhere they can. South Carolina has some preemption language on the books in their code section dealing with youth access to tobacco products, but more preemption was attempted to be added to their section of their code dealing with local smoke-free laws this legislative session. As I mentioned, that bill did not pass, but they want to get it in as many places as possible, it seems, which again creates another hurdle for us trying to work at the local level if we have to repeal it in multiple places. Just again would reiterate, looking everywhere, and I think it's really important for us to make partners with potential groups we've never partnered with before. If you'll go to the next slide, please. Here's a couple of bills that we saw recently. This first one didn't seem to have anything to do with tobacco or other issues that we deal with, but as it was related to commercial activity, we started to question if that would impact local smoke-free ordinances. And there's a lot of local smoke-free ordinances in the state of Texas where this language was introduced. It does not appear this bill passed, but this is just a really good example of language that may not have anything to do with what you're considering, but or specific to tobacco control, but could have broad sweeping impact had it passed. And then here's language that passed a couple of years ago in Iowa, and this was lumped into a minimum wage bill, and lawmakers were told that this was to preempt local regulations of plastic bags, prohibiting communities from prohibiting the distribution or sale or use of plastic bags. But as you can see, it doesn't mention plastic bags. It talks very broadly about the sale or marketing of consumer merchandise. And unfortunately, we've seen some industry documents and materials claiming that that does indeed preempt local regulation of the sale of tobacco products. So just a couple of examples here of broad bills and language that can be very sweeping. And I think both of these bills would also impact a lot of the healthy eating policies that we're considering as well. Next slide, please. And just going back to what the industry says, sometimes it's hard to know who's behind preemption language, and that is clearly by design. This quote is from Philip Morris, and they explicitly say that we try to keep Philip Morris out of the media on issues like taxation, smoking bans, and marketing restrictions. We try to provide the media with statements in support of our positions from third-party sources, which carry more credibility than our company and have no apparent vested interest. Next slide. This was a gem of a quote in a local media story out of Arizona. Representative John Allen sponsored a bad bill to raise the age of sale for tobacco to 21. In this article, his real intention is made clear. Allen told Capital Media Services that the issue of how old someone has to be to use products that have tobacco or nicotine is not the prime focus for pushing SB 1147. He was offering up the carrot of a higher age as an inducement to health groups to get them to accept what he wants, preempting cities and counties from enacting and enforcing their own laws on the marketing and sale of both tobacco and vaping products. Next slide, please. And then, as Mark mentioned, ALEC, you may have heard of them. They call themselves a membership organization dedicated to limited government, free markets, and federalism. It just so happens that many of ALEC's members are big corporations, including some tobacco companies. Anyway, this group, the American City-County Exchange, is a division of ALEC, the American Legislative Exchange Council. And I won't read through all of these, but suffice it to say they support preemption. I highly encourage you to check out their website. You can read through their 7 principles on preemption. They're all spelled out very neatly on their page. And you can also check if your local officials, your local elected officials are members of ACE or ALEC. And I would highly encourage you to check that out, because that can be a good roadmap as to who is going to help you and who is not. Next slide, please. So just a couple tips. If you're already preempted, try to repeal it, pass local control resolutions, make friends with non-traditional partners, build and educate your local base. It's going to take a concerted effort to get rid of preemption once you have it. Next slide, please. And if you're not already preempted, I highly encourage you to pass local ordinances. You may worry that this will encourage preemption, but that threat is already out there. Local ordinances help educate and help us build power. It's harder to take something away once it's in place. These preemption bills have been greased to move fast in a lot of instances, so it's really important to educate and mobilize early. Research tobacco campaign contributions to your state lawmakers and local elected officials, research who's a member of ALEC, and research who is registered in support of legislation. That can be very telling as to who's behind it. And the last slide, we are here to help. Don't hesitate to reach out. We have staff throughout the country, and my contact information is on the next slide, and with that, I will turn it back to.
All right. Well, thank you so much, Mark and Kathy, for getting us started with your expertise on preemption and the state examples that you shared with us. Providing us with the first of 2 state-level case studies on the topic is Lila Johnson, who serves as the Tobacco Control Program Manager for the Hawaii State Department of Health. Lila, thank you so much for joining us on today's virtual session. I realize that it's morning there for you in Hawaii versus afternoon for the rest of us.
Thank you. It's a beautiful morning, but thank you for the opportunity to share our sad story on preemption. Next slide, please. This is the Hawaii State Capitol, and I guess you could call it the scene of the crime. It's conveniently located across the street from the Department of Health, and we move back and forth underneath the street to go there during the session. The Hawaii State Legislature convenes the 3rd Wednesday in January, and it goes until the end of April. And good things can happen, and mischief can also take place. Today I'm going to speak about the 2018 session, and then I'll finish by bringing you up to date as to where we are now. Next slide, please. Prior to 2018, for the past 2 decades, we've been incredibly progressive and passing legislation, and particularly in the 5 years between 2012 and 2017. This timeline, it traces the adult smoking prevalence rates as they've gone down in accordance with legislation, and the highlighted yellow represents county ordinances. We've had the commitment of legislative champions and the tobacco prevention community to pass significant policies, including the passage of multiple county ordinances and state legislation such as the Clean Indoor Air Law, tobacco taxes, and especially Tobacco 21 law in 2015, which did put Hawaii in the spotlight. What has been key to Hawaii's success has been the strong and constant activity at the local county level. And we do credit much of our landmark legislation as being generated by the local ordinances. Next slide, please. Of course, there's been a great sense of pride and hopefully not hubris in the tobacco control policies that our legislature and the county council have introduced, supported, and validated by enacting laws. But we wonder if maybe being so far out in the Pacific, we for a time were under the radar of the tobacco industry. Well, after Tobacco 21, they woke up. They certainly woke up and they redoubled their lobbying efforts. We were naive and did not suspect that perhaps Hawaii may have had a target on its back to hinder further legislation. In the last couple of years, the tobacco industry has cleverly and effectively enhanced its resources. They've hired former legislators and government officials. They work behind the scenes to block good tobacco legislation. Next slide, please. We've seen a steady decrease in cigarette and other tobacco product use among Hawaii's adult and youth population. In 2017, we were down to 12.8% for adults and 8.1% for high school youth. However, the youth vaping epidemic has been festering. The use of ESDs, or electronic smoking devices as we call them here, began exponentially increasing among our teens. 16% of middle school youth and more than 26% of high school youth were current e-cigarette users. And this was even greater on the neighbor islands. This is at the same time that the national average was 13%. Next slide, please. So it was obvious that as a major public health concern, we had an urgent need to regulate electronic smoking devices, and the legislature began seriously to address this issue. Next slide, please. The 2018 legislative session had a ton of health-related bills, and most of those were on youth prevention and protection. We had bills trying to create buffer zones between retailers and schools, several of them to regulate electronic smoking devices, strong bill to ban tobacco and ESD use on the University of Hawaii campuses. There were cigarette tax bills, cigar tax bills, and also statewide smoke-free cards. The session proceeded with multiple referrals and committee hearings. Bills were deferred and moved forward effectively through the end of the session. One of the things, all bills, if they have any money in them, must be heard by both the Senate Ways and Means Committee and the House Finance Committee, and that is the last stop before it goes to Conference Committee. Next slide, please. So this is where the problem began. At the end of the 2018 session, we were down to just a very few bills that had made it through both houses and were ready for Conference Committee. But we had one very strong bill, which was Senate Bill 2654. And its title was specific to the tobacco tax chapter in the law. And this measure had passed by unanimous votes through 5 committees in both chambers. This bill provided for regulation of electronic smoking devices by requiring licensing and permitting through the Department of Taxation. It had a tax on e-liquids, and it included further safeguards to prevent underage youth from purchasing devices online. On the final day of the Conference Committee hearings, this bill was pulled. We had been given a heads up, but this didn't help it at all. Instead, House Bill 1895, which was a very innocent 1.5-page bill, whose purpose was to appropriate 3 positions for the inspection of dialysis units. It was instead amended, and 15 pages of new language was added to this. This new language created an unfunded retailer registration unit for e-cigarettes in the Office of the Attorney General, which is, everything else is in the Department of Taxation. It changed the delivery sales to be ineffective. It created a seizure and forfeiture clause, which involved persons under the age of 21 with administrative and judicial hearings and law enforcement, and most egregious, it preempted counties from regulating tobacco sales. This version of this bill passed, and unfortunately, it was signed by the governor as Act 206. This reflects with what Kathy had just said, because in this bill, as awful as it was, most disconcerting was deceptive language for preemption. Statewide concern. legislators were led to believe that the intent of statewide concern was really a good thing. They said it was the intent of the legislature to regulate the sale of cigarettes, tobacco products, and ESDs in a uniform and exclusive manner. However, all local ordinances or regulations that regulate the sale of cigarettes, tobacco products, and ESDs are summarily preempted. And sadly, existing local laws and regulations conflicting with this chapter are now considered null and void. Ironically, we have another anti-preemption. Next slide, please. We have an anti-preemption clause that protects where smoking is prohibited, but that one did not protect us. Next slide. So what did it feel like? We were blindsided, we were defenseless, and we were utterly disappointed. The tobacco control community had hoped for the governor to veto this bill. However, it created a huge conflict within the Department of Health because supporters of the dialysis bill were passionate in their need for the positions, and as much as we had hoped that the department would stand for a veto, it could not. The governor was also in a bind because he had promised help for the dialysis program early in the session. So this was the perfect storm. The perfect bill came along that could be taken, could be used, and we were literally sucker punched. The bill was unessentially unvetoable in an election year. Next slide, please. So that was 2018, and after that, over the summer and the fall, many meetings were held throughout the state. We even had a statewide conference. Armed for the 2019 legislative session, the tobacco control champions were energized. They regrouped and mobilized for a chance to correct the serious wrongs that had resulted from House Bill, Senate Bill 1895. And in 2019, over 50 tobacco-related bills were introduced this last session, among which were 8 addressing preemption. Next slide, please. Those 8 bills focused on restoring the county's authority to regulate the sale of tobacco products, including ESDs. And there has been a groundswell of community mobilization from the Hawaii State Association of County Governments, from individual counties, and even the governor's executive package had a couple of preemption bills. However, the tobacco industry was back. They again wove their tangled web behind the scenes to block these attempts. Sadly, not one bill made it past first decking. Next slide, please. So we still have preemption. The 2019 legislative session ended without any relief for the counties. The counties cannot promote or adopt innovative tobacco policies that deal with sales. And as an aside, as an issue as hot as the flavor ban has been, and the recognition that cities and counties on the mainland have been so successfully enacting laws, this cannot be done here at the local level. In our state, the Big Island County, or the County of Hawaii, has historically been a trailblazer. They were the first to pass smoke-free beach park laws, smoke-free cars, and Tobacco 21 originated there. So things happen so well on the county level and move forward. The situation is ugly, but the game's not over. The counties know that the vaping prevalence rates are highest on the neighbor islands, upwards of 30%. And they are now strategizing for the future. So yes, we have a formidable foe, it's out there, but Hawaii plans to reverse this awful curse called preemption. Mahalo. Last slide.
Thank you, Lila, for that valuable perspective on tobacco preemption in Hawaii. Last but not least, I'd like to introduce Ron Davis, the State and Community Interventions Supervisor with the Bureau of Tobacco-Free Florida at the Florida Department of Health. Ron, thank you for joining us.
Thank you. I'm going to start off by talking about how the industry pioneered their preemption strategy, and then I'm going to talk about the impact of preemption and the interpretation of preemption on our ability to pass effective policies in Florida. So we've heard in this presentation that the tobacco industry now routinely uses state preemption to protect its interests. Next slide, please. But Florida was actually the tobacco industry's first test case in the nation for the strategy of preemption. In the mid-1980s, 50 cities and 11 counties in Florida had passed local clean indoor air laws. The industry saw this as a significant threat and pushed to pass a weak statewide law, which included a preemption clause preventing any future local laws and repealing all of the existing local clean air ordinances. Next. The Florida Clean Indoor Air Act was originally proposed and supported by American Lung, American Cancer, American Heart to create a statewide minimum standard for clean air in Florida. The proposed law was severely weakened by strong lobbying from pro-tobacco forces who were organized by the Tobacco Institute, a nationwide tobacco industry-funded lobbying group. When the law was finally passed and implemented in 1985, the pro-tobacco forces had been successful in weakening many of the restrictions, removing criminal penalties in the act, and adding preemption. Preemption changed the law from being a statewide minimum law that had originally been proposed into being a statewide maximum law. As passed, the law allowed up to 50% of a public space, 65% of a restaurant, and up to 100% of a private workspace to be designated as a smoking area. Next. After the weaker law was passed, several attempts were made to remove the preemptive language, but the influence of the tobacco industry and other groups that opposed the law was too strong, and all of these legislative efforts failed. After years of getting nowhere with the legislature, pro-health groups decided that the only way to get a strong law would be to take this issue to the people of Florida. The Florida Constitution contains a process by which citizens can petition to have an issue placed directly on the ballot to allow voters to decide. Smoke Free for Health Incorporated, a 501c4 nonprofit organization, was formed. They were founded and funded primarily through the efforts of American Cancer, American Lung, American Heart, and the Campaign for Tobacco-Free Kids. They needed to collect more than 491,000 valid voter signatures to make the ballot, and they were able to do that despite competing with a Philip Morris-funded front group called Citizens for Responsible Solutions, which proposed a competing amendment to confuse voters. The measure was placed on the ballot and designated Amendment 6. In November of 2006, Amendment 6 passed by a vote of 71% in favor. Health advocates worked hard to make sure that good, strong language was used in the implementing legislation. Unfortunately, that strong language was folded into the existing act, which contained the preemption clause. Now, you may be asking, why didn't they use the amendment to remove the preemption? Well, the Citizens Initiative process in Florida requires that the Florida Supreme Court review the amendment to affirm that it addresses a single issue. Including a repeal of preemption in that amendment would have violated that single issue requirement and invalidated the entire amendment. Next. So I won't get into the details of the improved act, but basically the improved law states that a person may not smoke in an enclosed indoor workspace. There are some exemptions, however, and unfortunately bars are included in those exemptions. That was because polling indicated that the amendment would not pass if bars were included. Oddly, the original language of the act, before it was amended and after amended, stated that smoking is prohibited for any person under 18 years of age in, on, or within 1,000 feet of the real property comprising a public or private elementary, middle, or secondary school between the hours of 6 a.m. and midnight. This sentence, which prohibits youth from smoking outside school property, seems like a harmless provision, and it was really unnecessary because people under the age of 18 are already prohibited from smoking anywhere at any time. But this seemingly innocuous part of the law came back to bite us later. Next. The preemption clause, as written in the Florida statute, is shown here. There are two key words that I'd like you to pay attention to: smoking. This act only preempts smoking, not sales, possession, or marketing of lighted tobacco products, and it does not restrict or preempt tobacco products that are not smoked. The word ordinance is the other word to pay attention to. Initially, we believed that this preemption would apply only to laws of local governments, but the breadth of this preemption would later be interpreted to be much wider. Interpretation of the law can have positive and negative effects on our ability to enact policy changes. Next. Next, and next. So how is the law interpreted, especially this preemption law? Well, the letter of the law is what we can actually read in print in the statute. The legislative intent is what the lawyers try to infer from the context of the language in the law. This is not clear-cut, and it's subject to interpretation and to differing opinions. Previous case law can also be very important. And then we have the Attorney General advisory opinion. If an entity has a question about the interpretation of the law, they may choose to submit a question to the Attorney General for an opinion on the law. If they submit a question, the AG reviews the question and the law and gives an advisory legal opinion. The AG opinion does not become law, it's only an opinion, but because it comes from the Attorney General, it may carry additional weight in a court case. Next. So we're going to look at a few AG opinions and how they have affected our ability to proceed with policy here in Florida. This law is entitled the Florida Clean Indoor Air Act, so it would be natural to assume that it applies to indoor air. But the title of the law is only one part of interpreting the legislative intent. In 2005, the city of Margate wanted to pass a smoke-free parks ordinance. They requested an advisory opinion from the AG to ask if they could pass this ordinance. The AG's opinion states that the preemption extends to outdoor air, and they pointed to that seemingly harmless sentence about youth smoking outside a school as, quote, further evidence that the legislature intended to regulate smoking beyond indoor areas, end quote. Since part of the act includes outdoor air, it was the AG's opinion that this was evidence that the legislature's intent was to address both indoor and outdoor air in the act. Therefore, the preemption applies to both as well. Now remember that this opinion does not become law, it's an opinion. A city or a county could still choose to pass an ordinance that regulates outdoor air. In fact, some have done that. But if that ordinance were to be challenged in court, then this AG opinion would be referenced and may carry some additional weight. Next, please. In 2010, one of our Tobacco-Free Florida grantees was working with the Palm Beach County School District on strengthening their campus tobacco policy. Even though they were talking about a policy, not an ordinance, their district attorney was concerned that the preemption in the Florida Clean Indoor Air Act might be an issue. So they asked for an AG opinion. The AG concluded that the school board was preempted by the Florida Clean Indoor Air Act. This broadened the interpretation of the preemption to include policy, not just ordinances. Again, this was the AG opinion, not a law. So what would have happened if a school board had passed a policy anyway? Well, in fact, most of our school boards had already passed policies of this nature. They were enforcing them, and no one had attempted to challenge the validity of these school district policies. But Palm Beach felt strongly that they needed a legislative solution, and for a change, one came in record time. Next, please. In the next legislative session in 2011, the act was amended. The preemption added the clause that you see on your screen here. However, school districts may further restrict smoking by persons on school district property. This amendment helped school boards, but it was a double-edged sword. There was an opinion from the AG that this preemption included policy, not just ordinances, but this was not law. So the question of whether a policy was preempted was still open to interpretation. This amendment is law. By making a specific exemption for the schools to be allowed to pass their own policy, it makes it clearer in the law that any entity that wants to pass a policy must have a specific legislative exemption to do so. Very shortly after this was passed, next slide, we had another entity that wanted to pass a policy. In July 2011, right after the end of the legislative session where this was amended, St. John's Water Management District wanted to create a smoke-free policy on all of their property. They're considered a special district in Florida. As I said in the last slide, the specific exemption for the school board made it clear that to pass a policy, other municipal entities would need to be specifically permitted to do so in statute. And that's part of the problem with piecemeal changes to a law like this. They can have unintended consequences. The amendment took an area law that was questionable and made it more concrete, which had positive consequences for the school districts, but negative consequences for any other district. Next slide. So that specific language used is important and can have negative consequences, but it can also have positive effects. Remember that Florida's preemption says, this part expressly preempts regulation of smoking to, quote, the state. Well, the state is not the same as the legislature. There are other entities that are parts of state government. State universities are public institutions that function as part of the executive branch of state government. They are therefore considered part of, quote, the state. The vast majority of our state universities have now passed tobacco-free campus policies. In 2011, the same year that we learned that other entities couldn't pass policies, the Secretary for the Florida Department of Corrections enacted a policy making all state prisons smoke-free. And that's because they are part of the state as a part of the executive branch. Our state parks are another entity that would appear to have this authority. Some of our parks already restrict smoking in some areas. The state park system is an entity that we plan to reach out to about establishing more consistent smoke-free rules for their parks. Next. That's great for our state parks, but as we discussed with the city of Margate, this does not apply to city and county parks. We have some municipalities that have simply ignored this preemption and passed local ordinances enacting smoke-free parks. To this point, those counties have not been challenged. However, our state tobacco program cannot recommend this course of action to our municipalities, and our program cannot work with them on passing an ordinance that appears to be in violation of the preemption clause. So how do we work around this and try to help our local communities? Well, instead, we recommend a resolution and signage approach. We suggest the municipality pass a resolution with verbiage like, for the health and safety of all patrons, we ask that all visitors of the park refrain from smoking on park property. Next. Yeah, thank you. We then recommend signage that states this request. This is not a law. It's not enforceable. There are no penalties. This is a request. But the idea behind this is that the majority of people are rule followers. Most people who would not follow the request on this sign probably would not obey the sign if it indicated that it was a law. This signage helps to create an atmosphere of positive peer pressure to deter smoking. We're currently doing some research with our evaluators to see if this seems to make a difference in the parks that have the signage. Next. And to address the, next please. To address the deja vu that was in the title of my section here, our legislative session ended last month, and it was an active one for tobacco-related bills. A number of bills were introduced on subjects including raising the age of sale, restricting flavored tobacco, redefining tobacco products to include electronic nicotine dispensing devices, and including nicotine devices in the Florida Clean Indoor Air Act. Preemption provisions were introduced at some point in the life of several of these bills. In some cases, the preemption that was introduced would remove the ability of local governments to restrict tobacco marketing. That was covered in the first section of our presentation today, one of those bills. In another case, it would have prohibited local tobacco retail licensing. It's no coincidence that one of our counties, Alachua, recently passed the first tobacco retail license on the local level in Florida. So ultimately, all of these bills were defeated in the past session, but it's put everyone on notice that we'll be seeing more attempts at preempting local tobacco control legislation in the upcoming sessions. Next. And that's it for me. Thank you very much.
Thank you very much, Ron, for sharing Florida's case study. We have time for a couple of questions and answers, and I'll be turning this over to Josh Berry, Senior Analyst of the Chronic Disease Prevention with ASTHO. Take it away, Josh.
Terrific. Thank you, Christina, and thanks again to all of our speakers for joining us this afternoon. We do have a couple minutes for questions before we wrap things up here at the top of the hour. So I do encourage anyone, if you have any questions for any of our participants, to please use the chat box at the toolbar of our Zoom platform to be able to submit questions via the chat box. And to get things kicked off, I have a question that I'd like to direct to Lila and Ron after hearing about all of the examples in both of your states in terms of tobacco preemption legislation taking hold and being blindsiding at times. So first to Lila and then to Ron, knowing what you know now, what kind of action do you wish that your state health agency might have been big in terms of educating legislators or maybe doing something else in order to perhaps stave off those preemption bills that we've seen as doing damage to public health policy in your states?
It's really hard. I think helping them understand that preemption is not a good thing. As I said, many of them were convinced that by the way it was written that they were really doing something positive, and for them to realize that, you know, it truly is egregious. It's very, very damaging. We also, you know, there are a number of legislators that seem to be much more receptive to the tobacco industry. If we would to change their hearts and be able for them to understand and not basically take the kind of recommendations that are coming from the industry would be helpful. Those are not real strong recommendations that I'm able to give you, but that's sort of where we are now.
Understood. Appreciate your insight, Lila. Yeah, go ahead, Ron.
Sure. I would say that every state should be on notice based on our experience that this is coming. If it hasn't come to your state, this is coming. And I would say be prepared to show your legislators when these things come up, what would this preempt? You know, what would this, what local laws would this take out that currently exist? And what would this prohibit you from doing in the future if this preemption exists? Go ahead and make those lists now so that you're not trying to scramble when you get into the legislative session to pull those lists together or that information together, and make sure that your advocates out there, the tri-agencies and other advocates that you have, are armed with this information as well.
Terrific, Ron. Thank you for your insight. So I also see the folks adding questions to the chat box, so thank you very much for that. Have a question here that I'd like to turn to Mark. Mark, from your perspective, how do you get policymakers to understand in the negotiation of bills that adding preemption ought to be a deal breaker and not something that ought to be considered in terms of negotiation?
Well, that's a great question, Josh. And it's a little bit outside of the scope of what we do. Kathy might be better in a better position to answer that. But I think that we, our view is we work with, since we don't work directly with legislators, we don't do any lobbying. We work with folks, who are experts in the field, like Kathy, like Lila, like Ron, to help them understand what the implications might be. And I think that, I think we look at the history of preemption, how we are seeing it, how ubiquitous it has become, how pervasive it is, and how courts are sometimes doing it. And I think it's showing the effect. I think what we would like to see more is more evidence to show what the tangible effects are of it, because I think we can explain and we can show the types of policies that are that could have been passed but for preemption. But it's hard to it'd be nice to have some more quantifiable results of what the public health benefits or what the detriments are of preemptive laws. But Kathy might have a better answer than that. That would be more directly on point.
Sure. Yeah.
No, I think.
Go ahead, Kathy.
Yeah, I think that you covered it, Mark. I think just the more specifics that you can provide to lawmakers on what the exact impact is going to be for their constituents, that's where I think it's really important to have as many local ordinances in place as possible, because it's really hard to take that away once they are in place. I think also just educating lawmakers on this is what the tobacco industry wants. A lot of lawmakers are new, haven't been engaged in tobacco control policies for a long time, and there's a long history of industry pursuing preemption. And sometimes it's as simple as explaining whose side are you on, kids or big tobacco. And that can be an eye-opening conversation for some lawmakers. Others are harder, and that's where having a broad base of partners and being able to explain what the long-term ramifications of this policy can be really come into play.
Terrific, Kathy. Appreciate your insight there. Seems like a compelling point there that can be made. And I do want to apologize for the attendees who are submitting Q&A, seeing that we're already at the top of the hour. We do want to move to conclude, but we will be passing around slides to attendees joining us this afternoon, and we do encourage folks to follow up with all of the speakers who have graciously offer to make themselves available and provide further information. So I'm very happy to see the engagement from those participating. But in the interest of wrapping up and trying to keep on time as much as possible, I would like to turn things over back to Christina to take us away and take us to conclusion. So Christina, floor is yours again.
Okay, thank you so much, Josh. And thank you to Kathy and Mark for providing those valuable resources that you're seeing up on the site right now, and to Lila and Tehran for sharing their 2-state case level studies. Just fascinating. I took many notes. So as we conclude, as a reminder, there are resources available on the Public Health Law Center and TCN website. The Public Health Law Center, publichealthlawcenter.org, contains a number of resources dedicated specifically to tobacco policy preemption. So please check out those resources. These include a comprehensive tobacco preemption doctrine, fact sheets, point of sale documents, 1-page briefs on preemption. The same expertise that Public Health Law Center provided in today's virtual session is available in their host of online materials. We also encourage everyone to visit the TCN website, tobaccocontrolnetwork.org. Our website offers a wide array of resources designed specifically for state and territorial tobacco control programs and partners. And as a reminder, TCN has an interactive map. We have a mailing list where you can receive our twice-monthly TCN newsletter. And also you can send any questions that you might have to tcn@astho.org. This concludes today's virtual session. And once again, I'd like to thank Mark Meany, Kathy Calloway, Lila Johnson, Ron Davis, and Josh Berry for being on today's virtual session. I wish we had more time to answer more questions. But please submit your questions to our speakers. I'd also like to thank all the staff at ASTHO and the Public Health Law Center who made this virtual session possible. Thank you so much to everyone who joined our webinar today. We appreciate your interest in the TCN webinar series. And please join us for the 3rd and final series. We'll send out information soon. Thank you and have a nice day.